Over the last fortnight, I've been involved in a number of meetings with members explaining the current situation in respect to the casuals issue and our legal cases in relation to the WorkPac class action, but also matters in the High Court concerning the position of what we call permanent casual employees. Whilst I managed to see quite a number of members and report on the situation, we did receive requests from a very large number of members who couldn't be there for there to be a video report of my discussion with members for those who couldn't make it. So this is a shorter version of my presentation, and I hope that after this discussion we have a bit of a clearer idea of where we stand currently, given some very significant developments in terms of government legislation. So to take a step back, the Skeen and Rosado cases, which have been driven by the union to protect and enhance the rights of casual employees, goes back about 10 years. And it's all part of an effort that the union's been consistently driving to ensure that workers who are in fact permanent employees but are being labelled as casuals receive the benefits of permanent employment. Now, the first case, a significant case involving Paul Skeen, was originally lodged in 2014, and because of appeals, etc., a final judgment in that matter wasn't decided until late 2018. Now, that situation led to a real landmark finding by a full court, which basically came down with an unremarkable principle, really, that if it looks like a duck and quacks like a duck, it's a duck. So if you're actually a permanent employee and you might be labelled a casual employee, but if you work permanent hours according to a permanent roster, day in, day out, you're not a casual. You're a permanent employee or an ongoing employee, and you should be entitled to the benefits of permanent employment, such as annual leave, personal leave, etc. So, following the landmark Skeen case, the employer WorkPac, rather than appealing that decision in the High Court, as is the normal practice, contrived a separate proceeding where they would effectively try to rerun the case using a different employee, Mr. Rosado, and hopefully obtain a different result from a differently constituted federal court. Now, that proceeding, which became known as WorkPac versus Rosado, also ended up before a full court of the federal court, and in that matter, the employer WorkPac lost again on a 3-0 basis, with the full court deciding that the earlier Skeen decision that we ran was correctly decided, but also going into more detail about why WorkPac were not entitled to offset their casual loading against the flat rate of pay that our members received, which we were claiming. So the Rosado exercise for the employer was a failure, and as a result, the employers, the big business lobby, WorkPac, ran off to the LNP federal government and demanded a legislative fix. They demanded that the law be changed to disentitle workers like Paul Skeen and Robert Rosado from back pay for annual leave and other entitlements. And part of their campaign, which you probably would have heard about, involved claims that there was a process of so-called double dipping involved, because as casuals, you would have been already compensated for your lack of annual leave and so on, and that the union claims in relation to back money and the fact that we launched a class action on behalf of our members, of which many of you are part of, would lead to billions of dollars of money being forked out by employers, and outrageously, including, they say, small business employers on the basis of a double-dipping claim. Now, that claim is nonsense. That notion that there is double-dipping is nonsense, because we all know that labour hire employees in the coal mining industry and the mining industry generally are normally paid between 30 and 40% less than the direct employees of the big mining companies. So there's no double dipping, there's just a double standard by employers when it comes to properly recognising and paying employees in the industry. So in response to the employer lobbying, the LNP federal government didn't say, no, we're going to protect the interests of ordinary workers in the mining industry. They didn't say, look, the courts have spoken and we have to abide by their ruling on the law. What they did was essentially produce a set of amendments to give employers everything that they want, everything that they couldn't by their arguments in the court system achieve. So when the Omnibus Bill was introduced in late 2020, it contained a set of provisions relating to casual employees, which was directly aimed at unravelling, undoing our victories in the Skene and Rosado cases. It's one of the most outrageous direct attempts by a government to interfere with the rights and entitlements of workers. Now, what happened further was the legislation was presented to Parliament, and of course the government has the numbers in the lower house and duly passed the legislation. But when it got to the Senate, there was a real question of whether the crossbenchers, because the government doesn't control the numbers in the Senate, but whether the crossbenchers will do the right thing by workers and vote these provisions down. So there was a lot of argy-bargy and lobbying in the Senate, and this is in February and March of this year. And ultimately it came down to 3 members of the crossbench holding the balance of power on the question of this casuals bill. And previously, Jackie Lambie, the Greens, Labor, all the other independents had effectively said no to the government's proposal relating to casuals and the other provisions. But there are only 3 standouts that were a possibility, and they were One Nation, Malcolm Roberts and Pauline Hanson, and Sterling Griff from South Australia, from the Centre Alliance, or whatever they call themselves. Now, in the end, those 3 senators voted to sell out. There's no other word or expression that suits the situation. They voted to sell out mine workers in the regions and all other workers who had been falsely classified as casuals. And this is despite the fact, and I know because I was in the Senate committee hearings arguing this position on behalf of workers, despite the fact that Malcolm Roberts purported to be the best friend that coal miners and mine workers generally had ever had. He was using our arguments in the Senate committee hearing to decry how terrible the situation was with casual employment in the coal mining industry, but then proceeded a couple of weeks later to vote in favour of the LNP legislation to sell out workers like yourselves. Now, it's not my business to tell people how to vote. I'm not here to do that. But I think you should remember when the next time the next federal election comes around, just who did what in this sordid episode in the Senate. And clearly, if you are concerned about this casuals issue, this question of the permanent worker being labelled a casual, then you must really show that at the ballot box by putting the LNP and One Nation last. But that's an issue for down the track. But what I need to say is that the legislation that the government has introduced and which passed does have a serious impact upon your rights and upon, in particular, the position of our members who are subject to this class action. And the best way I can put it is that in the best case scenario, in relation to the class action, the value of the claim is diminished. We don't know by how much, but quite substantially. So whereas a couple of months ago, we could have been relatively confident of a positive result as a result of our class action, with members obtaining pretty much all of their claimed compensation. That claim, the value of that claim, is now going to be substantially reduced as a minimum. In a worst case scenario, the position will be that the class action won't be able to go ahead. And that'll be because the legislation introduced by the LNP government has retrospective effect. That means it applies not only to new matters, but to existing matters commenced prior to the introduction of that legislation. So the news isn't good. I wish it could be better. And we won't know the precise position until the WorkPac and Rosado matter is determined by the High Court. We can only hope that the decision that the High Court comes down with is supportive of the two previous full court, federal court decisions on this question. And when that decision is known, we will obviously assess our position in terms of the way forward. So, unfortunately, the position that we're in at the moment is not as positive as it was a few short months ago. Now, that's to do with big business and their supporters in the government deliberately seeking to take away your rights and entitlements because they can, and because when it comes down to it, they are really interested in the top end of town, the big mining companies, the big labour hire companies, and your interests are really secondary. I don't have any joy in saying that. I wish that the position was otherwise, but the reality is that this government has chosen which side it's on, and it's decided that your interests are secondary. So, in conclusion, the fight is not over. It's not over by a long stretch. We will continue to pursue this issue, and we will communicate with you when the position becomes clearer about our class action and the related legal proceedings. But you can remain absolutely reassured that this union will not back down on fighting the permanent casual rort. We will pursue this government, will pursue the pretenders who say that they're on the side of workers, and we'll get to the position one day where is as it should be. Workers who are permanents are treated as permanents in all respects, wages, conditions, and all the rest. And this rort, which has been a curse on the industry now for more than a decade, is done away with.